Well, good morning, everybody. Welcome to King's Chamber's series of professional negligence seminars. We're delighted that so many of you were able to join us. For those of you who don't know me, albeit my name I think appears on the screen, I'm Lesley, and I've got with me Dr. Nathan Smith, my colleague. As I say, this is the first in a series of lectures dealing with professional negligence topics. I'm sure that you've signed up for some of the other ones, but for example, the next one is on causation and loss for chance. That's Johnny Ward and Faye Collinson. That's on the 22nd of September. After that, there's ones on limitation with Ben, Harding and Chelsea. And then we have damages on the 10th of October. And finally, on the 16th of October, Andrew Grantham and Aidan Ray are talking about PI and insurance, so the insurance aspect of it. Today, we're dealing with scope of duty and professional negligence claims. I hope you're all able to see the slides. Obviously, the starting point in any professional negligence series is obviously to talk about the duty question. And of course, you will probably all be familiar with the fact that Manchester Building Society and Grant Thornton has been a recent restatement of these principles by the Supreme Court. Now, it's fair to say you're probably all familiar with the facts, but we've simplified them down significantly in this because it was more complicated than this. But essentially, Grant Thornton was the auditor of Manchester Building Society and wrongly advised that it could use hedge accounting when it couldn't. So again, that's pretty simplified down. So Manchester Building Society based on that advice, they entered into various long-term interest swap contracts. When it was realised that the advice given was wrong, they had to close out all the swaps at quite a significant loss. Now, I'm not going to deal with the first instance decision or indeed the Court of Appeal, but by the time we get to the Supreme Court, the Supreme Court took the opportunity to restate the principles, including in relation to the duty question. Before I get to duty, I just want to tell you that a series of 6 questions essentially were formulated. And I also to say that this was the decision of the majority. There were, in fact, rather unhelpfully, I think, 3 different decisions given, albeit all leading to the same result. But the reasoning was slightly different. But I'm going to deal with the reasoning of the majority. So the majority held that in negligence cases, a series of 6 questions arise, the so-called 6-stage test, including, so far as today's seminar is concerned, what are the risks of harm to the claimant against which the law imposes a duty on the defendant to take care? And that's usually referred to as the scope of duty question. And then fifthly, the 5th element of the 6-stage test, is there sufficient nexus between a particular element of the harm and the subject matter of the duty of care at stage 2, the so-called duty nexus question. And that's what we're going to be focusing on very much today. Now, it was an enlarged panel of 7 justices, and essentially it was unanimously agreed that the losses in question that were suffered by the building society were within the scope of the relevant accountant's duty of care. But as I say, in doing so, they came up with slightly different reasoning in relation to it. In relation to the particular question of the scope of duty of care, we can go to the next slide. So what the court said was that the scope of the duty of care assumed by a professional advisor is governed by the purpose of the duty, judged on an objective basis by reference to the reason why the advice has been given, and, as is often the position, including in the present case, paid for. And that was paragraph 13 of the judgment. Now, we're not going to use the rest of today to deal with Manchester Building Society. That's just to set the framework for it. So at this point, I'm going to hand over to Nathan, who's going to introduce, or who is going to talk to you about some of the more recent cases on the point. Nathan?
Yeah, thank you, Lesley. So I've got a range of cases that have come since 2022, in 2023 and up to this year. It's about 15 or so that I'm going to talk about. I may discuss what's happened in a range of different professional negligence situations, including solicitors, valuers, structural designers. But ultimately, they're all applications of principle that Lesley's been talking about in the Manchester Building Society case. It's interesting to see how the law has developed since that initial Supreme Court decision. Now, one of the first cases to apply and summarise the principles from Grant Thornton was the case of Oriam Real Estate. This is a case where a holding company claimed damages for professional negligence in connection with advice received from the respondent law firm. The company in this case had earmarked the site for development. It had assembled freehold titles, persuaded leasehold tenants to surrender their leases, and even obtained planning permission and negotiated with a buyer for a sale of its shareholding with vacant possession of the site. But one business tenant, a shop, refused to vacate the site, and the company contemplated building around the shop. And the law firm gave advice about the extent of the tenant's rights under a lease. But the interpretation and scope of the advice were disputed. The company thought the advice had confirmed that a build-around strategy was a viable option and therefore stopped negotiating with the tenant. And then the tenant issued proceedings for a declaration that the build-around breached the lease terms. The buyer ultimately withdrew from negotiations, citing the uncertainty created by the tenant. Now, the tenant eventually agreed to leave, but the buyer was no longer interested in shareholdings. And this was the background against which Oriam pursued a claim against the solicitors. Now, the claim failed for a number of reasons. The first one being that, in fact, Oriam was found not to be the counterparty to the contract to provide any advice. But the court went on to consider whether the losses claimed would have fallen within the scope of the duty of care anyway. Paragraphs, I think, 68 and 69 onwards. And in order to answer that question, the court looked first at the contractual position between the parties to see what the scope of the retainer was. And that's obviously the first step that you need to take in any case involving allegations of professional negligence, to see what it is that falls within the scope of the retainer. And then once that's worked out, the court then looked objectively at what the purpose of the advice was in this case. And it was held that the firm had not been under a general retainer to provide all legal advice, but was engaged on a matter-by-matter basis, and that the purpose of the advice was to guard against the risk that some aspect of the tenant's rights and obligations were overlooked, not that Oriam would be unable to sell its shares because of a tenant's refusal to give vacant possession. So that's quite a good first example of applying this test to a case where a wider scope of duty was alleged, but the court cut that down and dismissed the claim. The next case, moving forward to January 2023, is the case of Anand Kasi or KC Company Limited. It is actually a Court of Appeal decision in relation to the assessment of damages in patent infringement proceedings. So a bit outside the usual scope for professional negligence claims. An earlier trial had already determined that a patent had been infringed, and there were a number of heads playing on the damages inquiry. This isn't a case that was so much concerned with scope of duty, but it was more concerned with legal causation. But there's still a point that comes out of it, because the Court of Appeal held that while the Manchester Building Society principles were of some relevance in considering assessment of scope of duty and causation, they didn't substantially modify the framework for a damages inquiry in this context, that's to say, patent infringement. And there's one other point as well that I think it's worth bearing in mind. When looking at legal causation, that is, of course, a matter for the evaluative judgment of the court. And if a judge has correctly directed themselves as to the law, it can be quite difficult to appeal unless there's some sort of error of principle or no reasonable judge could have reached the same conclusion. I think of more relevance in this context is the URS Corp decision. This is another development case. The claimant engaged the defendant to provide structural design services for 2 developments of residential apartment buildings. Those buildings were actually sold for full value, but then it was discovered that there were structural defects in them, albeit no physical damage. But the claimant brought a claim in negligence for the damages for the costs that it incurred in investigating and remedying the issues. Now, procedurally, the case was an appeal against the determination of certain preliminary issues. But so far as relevant to this talk, the Court of Appeal, in which Lord Justice Coulson gave the leading judgment, upheld the trial judge's conclusion in respect to the scope of duty arguments. That's to say, namely, that the risk of economic loss caused by structural deficiencies or defects was clearly something that fell within the scope of duty of a structural design engineer. Now, that was a well-established case prior to Manchester Building Society, and Lord Justice Coulson doubted whether, in those circumstances, a 6-stage checklist was directly applicable, but still thought it was useful as a sanity check. It said it was primarily, that's to say, the 6-stage test was primarily directed at novel situations. And this case is one that's cited in later authorities and has been built upon to distill some principles from the Manchester Building Society case. One of those is the case of Glover and Fluid Structural Engineers. This is actually a case before His Honour Judge Stephen Davis in December 2023. Now, this was another case of more limited private development, but the claimers were the owners of a substantial house in West London, and they wanted to refurbish and extend it and construct a basement underneath it. The defendants, FSE, were again structural engineers and designers and appointed to oversee certain aspects of the project. Perhaps unsurprisingly, as happens in these cases, things didn't go to plan and cracks were caused to the property and neighbouring houses. FSE undertook an inspection and in June 2019 produced a report which incorrectly identified the way that the main contractor had carried out the works and what they should or shouldn't have done. The main contractor was then dismissed and went into liquidation, and the claimants ended up in litigation with the main contractor's insurers, which they lost and had to pay the costs of. And there was therefore a claim brought for professional negligence against FSE, which FSE applied to strike out and or for reverse summary judgment. You know, I might have noticed if you read these decisions that insurers often, or professionals often, take the point, if they can, at an early stage that there's some difficulty with the scope of duty of care or causation or something like that. So it's important to identify exactly what your case is with some detail early on. In any event, applying the MBS decision, His Honour Judge Stephen Davis held that there was no reason to regard the incurring of investigation costs and legal expenses as being outside the scope of duty of a construction professional. The application for reverse summary judgment strikeout therefore failed. The case is interesting there for another reason, because the judge distilled down 7 points from the earlier case of URS Court and indeed the case of Manchester Building Society that it was based on. And I'll just run through those because quite useful to have in mind, and also obviously useful to have a case that summarises principles more succinctly whenever you're involved in a litigation anyway. So the first was that the fact that the defendant owes the claimant a duty to take reasonable care does not mean that the duty extends to every kind of harm which might be suffered as a result of a breach. Secondly, following on from the MBS case, you have to ask whether and to what extent the loss for which damages were claimed was within the scope of the duty. Thirdly, the burden of proof lies upon the claimant to establish that it does. Fourthly, whereas here the scope of duty question is relevant to the extent of the loss of a particular kind, it's generally more appropriate to examine this after first ascertaining on a simple but-for basis what is the extent of the loss which has flowed from the alleged breach of duty. And that means identifying the losses which are in fact in issue so that you focus upon them with greater precision when considering whether or not they fall within the scope. Fifthly, the scope of the duty of care assumed by a professional advisor is governed by the purpose of the duty, judged on an objective basis, as Lesley was saying, by reference to the reason why the advice is being given and paid for. Sixthly, the distinction between advice and information cases is too rigid. You might remember that was a distinction that came out of some of the valuer cases prior to MBS, which was used to try and say what the extent of the scope of the duty was in earlier cases, but that's been effectively held to be unhelpful following Manchester Building Society decision. And then seventhly, the starting point is to consider the purpose of the obligations pleaded by the claimant as having been owed to them. And that seventh point is important because, especially given the propensity for defendants and insurers to apply for summary judgment or strike out if there's a viable argument on it, it's very important to make sure that the pleading identifies the risk that you say the advice was there to protect against. And of course, it's also important to consider what the professional agreed to do under the retainer in the first place. So applying those principles to the case before him, the judge concluded that or rejected the argument that there was any clear dividing line that should be drawn between more conventional types of loss that are recoverable against structural engineers from, for example, costs of investigation or remedying defective work, and legal litigation-related costs that arise. It's more nuanced, he said, when you apply the Manchester Building Society principles. The next case is Hope Capital and Alexander Rees-Thompson, a case from September 2023. Now, this is a claim against the valuer. Valuer claims have always had issues of scope of duty running through them following Samco and earlier decisions. In this case, the property was valued at about £4 million on February 2018 for a bridging loan, or to secure a bridging loan of about 2.2 million. In fact, the true value of the property was close to 2.475 million, which was outside the bracket that the judge held was applicable of 15%. And so there was prima facie a case of the judge accepted, I think, in this case, that the valuation was negligent, but nonetheless, the claim still didn't succeed. The judge didn't think that ART had accepted responsibility for all the consequences of the transaction on the basis of the overvaluation. And so even though the property was eventually sold for £1.4 million, ART wasn't responsible for the losses that flowed from that. The reason for the sale being at a lower price was related to issues to do with COVID, the conduct of the borrower, and the Section 146 notice that had been served and that caused delays. Now, there's also a useful summary of the principles in this case as it applies to valuers. So, firstly, as I said before, the categories of advice and information aren't distinct or exclusive, and probably not that helpful in terms of analysis anymore. Secondly, you have to focus on the purpose for which the advice or information is provided when considering the scope of a duty of care. Thirdly, the importance or criticality of the information provided by the professional to the client does not of itself determine whether the damages fall within the scope of the duty. It might be relevant to the question of purpose, but fourthly, and in cases involving valuers, it will usually be clear that the responsibility is limited to their particular area of expertise. And fifthly, the court also said that counterfactuals probably not going to be of assistance, but might be some sort of tool. And for those who are familiar with the earlier case, or often the case of people considering counterfactuals, that's to say what would have happened if the correct advice had been given, developed quite convoluted arguments about them. And ultimately, the Supreme Court thought that that sort of argument was secondary to just looking at the purpose of the advice and the risks that it was protecting someone against. And so the judge, looking at all of that, applied the principles to the case before him and concluded that in this case, the purpose of the advice was to provide the lender with an opinion as to the current market value of the property And that will often be the case in commercial valuations. There was no evidence that elevated this, in this case, to the rare situation where a valuer's duty is taken to be one that extends to protecting the lender against all the risks of the transaction. And incidentally, in this case, there was also an argument about contributory negligence too, which is a common feature of these types of claims. And the judge would have, in fact, applied a 50% reduction in any event because of circumstances surrounding the lending. For example, the lack of viable exit strategy and failure to take account of the poor credit rating of the borrower. Next case was still in 2023, Oxford Property Investments Limited. This is another case, in fact, where the defendant firm solicitor had applied for reverse summary judgment on a claim that had been brought. And now the defendant in this case had been instructed to act for the second claimant, which was a special purpose vehicle that had been incorporated to purchase a property. There are several aspects to the claim, but given that time we've got, I'm just going to focus on one of them. What happened was that the second claimant, or the claimant by the time of this application, didn't receive the full finder's fee that it had agreed to. And it blamed the defendant's solicitors for that because it failed to ensure that an oral agreement for that fee was binding. And it also said that it failed to advise it to obtain development finance in order to purchase the property itself, and claimed loss of profits. The interesting part of this actually relates to a proposed amendment that Oxford Property Investments wanted to bring to its claim to also claim anticipated loss of profits on subsequent developments, and that it was going to use the finder's fee to finance and was unable to do. Now, the court refused permission for that amendment, even at the summary judgment stage, because it was satisfied that the scope of any duty of care did not extend to the risk of losing profits on subsequent developments, which the solicitor's firm was not retained to advise in respect of anyway. And the judge said it would be a starting argument, in fact, if the contrary were true. That's to say that there was no clear factual legal basis to allege that even if a solicitor is not retained in respect of an additional transaction, it is a duty of care as if it were retained because the additional transaction is intimately connected. If there was no retainer in respect to the subsequent properties, it couldn't realistically be said the same duties arose out of the retainer that related to the first property. So I think this is a really interesting case, actually, if you have a situation where you're representing or acting against a professional and there's a loss associated with a transaction that's outside the scope of the original retainer, because this case at least would suggest that that loss is also going to be outside of scope. Miller and Irwin Mitchell Limited, moving forward to 2004. Now, this is a case where a claimant sustained injuries in an accident in May 2014 while on holiday in Turkey. At the 19th of May, the claimant rang the defendant's solicitor's free legal helpline and had a telephone conversation with one of its operatives. But it wasn't until January 2016 that the defendant informed the claimant that it was ready to proceed with her claim and sent her a conditional fee agreement to sign. The letter of claim was then sent, which the travel operator forwarded to its insurers in March 2016, over 21 months after the accident had occurred. But the insurer declined cover for the claim on the ground that the travel operator had notified it of the claim late under the terms of the insurance policy. And the travel operator, unfortunately, then went into administration as well. So the claimant brought a claim in negligence on the basis that she had entered into an express retainer with the solicitors in May 2014 when she called the helpline, and argued that she should have been advised during that call to notify the travel operator of the accident immediately. The judge at first instance, Judge Cadwallader, rejected that argument and held there was no retainer prior to January 2016 and no duty to provide the advice claimed on the helpline call. An appeal against that decision was also dismissed. And while the Court of Appeal held that the fact that the advice was provided gratuitously on the helpline was not a bar to finding a duty of care, the advice was only general and preliminary and that it was anticipated more detailed advice would follow on the specific circumstances of the case. And the defendant also was found not to have assumed responsibility for the risk that the travel operator already knew about the accident but would not notify its insurer in time. So if you were to look at this case, it really draws a distinction, I think, between general and preliminary advice and more detailed subsequent advice, and the sort of risks that you can reasonably expect the initial preliminary advice to protect against when compared perhaps to more detailed advice when the full facts of the case are known. The next case is from November 2024. This is again a case to do with a property development. The claimants in this case wanted to convert the outbuilding of a property into residential accommodation and engaged an employee of the defendant to assist with that development. That included obtaining planning permission. That was a change of use. Permission for a change of use was obtained, I think, in April 2016, but had a condition attached to it that the existing building should not be demolished or replaced with a new structure. The claimants claimed that in a meeting in May 2016, a month later, they were advised by an employee of the defendant that in reality, once planning permission was granted, if it was demolished and rebuilt, the planning authority wouldn't object as long as it looked very similar to the pre-existing building. Now, as a result, the builders began to demolish the building, but a planning officer visited the site in October 2017 and stopped the works. The defendant was held to have been negligent, but there was an issue as to what losses fell within the scope of your duty of care. There were 9 heads of loss in total, ranging from payments to the builders, project managers, ancillary and legal costs, mortgage interest, penalties, and loss of value. And in fact, there's a loss of chance claim as well. Now, the judge considered that the advice was to protect against. Well, the judge considered what risk the advice was to protect against, and in doing so observed that the employee must have known or be taken as having known that there was a significant risk of there being a calamitous intervention by the council if there was a significant deviation from the planning consent. The fact that enforcement action had such a disproportionate effect compared to the fees received by the defendant was also not something that affected the risk that the advice was protecting against. And the judge observed, in fact, that was not something the defendant had sought to control by its contractual terms and conditions. And so while it had some bearing on the scope of the duty of care, it was ultimately up to the parties to moderate the effects of that by contractual terms if they wished to do so, but didn't. And the judge therefore concluded that the losses fell within the scope of the duty. So again, there's an interesting point, I think, in this case, which comes from the fact that the lack of proportionality between the potential losses and the fees charged for advice is not necessarily something that's going to carry a huge amount of weight when it comes to looking at whether the losses are within scope. And you really need to address that in terms and conditions if you want to make the point. Milford Investments Limited, this is a December 2024 case decided by His Honour Judge Pearce. Again, a case brought by a professional negligence claim against the solicitors who are involved in a proposed property development. Yes, so I'm not going to spend too long on the facts of this one, but this contrasts with the earlier decision I was talking about. In this case, it was found that the scope of the duty extended to advising in respect of the development and the ancillary research and the ancillary services. So when the buyers withdrew from the purchase, this was a claim that was held to be within scope. And so I'm not going to go into the facts of that, given the time we've got, but maybe contrast that with the earlier decision where against Mishcon, where the duty was more limited. Christian Mary Ward Legal Centre. Now, this is a case from earlier this year in February 2025. The claimant was a local authority tenant, and the council commenced proceedings against her for arrears of service charges. Following litigation about the reasonableness of those charges, notice to forfeit the lease was served, and the council commenced proceedings for forfeiture. The claimant went to a law centre. A law centre instructed counsel to advise on the merits of defending the proceedings on the grounds, amongst others, that there had been a waiver of the right to forfeit as a result of accepting payment. Counsel advised that it probably wasn't a waiver, but that the claimant could apply for relief if she paid the sum that was owed, which was just over £14,000 at the time. And that the £20 per week that she was offering was unlikely to be accepted. Therefore, counsel advised that the prudent course was attempt to adjourn the proceedings to sell the lease. An adjournment was obtained. Barrister ceased to be involved, and the claimant continued to act in person. And when the proceedings came back before the court, the claimant unsuccessfully argued, in fact, that the council had waived its right to forfeit, and the judge made a possession order. The claimant then sold her flat in July 2013 and paid what was due. Now, some time passed, and it wasn't until the 15th of July 2019 that the claimant then brought a claim against the barrister and the law centre, alleging that she should not have been advised to sell the flat, and instead she should have been advised to transfer her claims to the Administrative Court for judicial review, and secondly, that she was eligible for a rent contribution from the landlord, and also that she was eligible for a loan from Southwark under a service charge loan scheme. There were some other points as well, but perhaps unsurprisingly, the court held that when being asked to advise on waiver, while counsel's duties extended to advice on relief, it certainly didn't extend to the other three matters that I just mentioned, and so those losses were outside of scope and indeed probably outside the retainer too. There was also a point about the extent to which the scope of duty would have included subsequent changes to the value of the property as well. So what was said was that the property that was sold had increased in value to about £450,000 by October 2024. But even if a breach had been established, the judge said, again, perhaps unsurprisingly, that the value or an increase in the value of the flat was in any event outside the scope of the duty of care. Subsequent movements in property markets generally are outside the loss of outside the scope of any loss covered by a lawyer's breach of duty. Next case from March 2025. This is a case against Anthony Gold solicitors, which the firm applied to strike out again, reverse summary judgment. In this case, it was actually a claim. It was a claim that related to a property purchase that didn't proceed again. The claimant had obtained a mortgage offer from a bank and borrowed £70,000 to complete the purchase as well, but was unable to transfer those funds. There was an argument, I think, about what the bank had been told by the solicitors, and some incorrect information was provided. But ultimately, the court was satisfied, even at the sort of summary judgment at stage, that the reason why the bank had withdrawn the mortgage was the claimant's use of a second loan, not the mischaracterisation of the funds as a gift. And therefore, the claim failed before it got to the scope of duty in question. So the scope of duty question, in fact, on factual causation, say but-for causation. But what you do get from this case is that that's the right order in which the issue should be addressed. You might remember His Honour Judge Stephen Davis, and one of his principles said that you need to look initially at the factual causation to see what losses are actually within scope before, to see what losses there actually are before deciding whether they're in scope. And that focuses attention on those losses. I just want to skip forward to a case called Bratton Jones, because it was the Court of Appeal decision, again involving valuers. And the point in issue in this case was actually whether when you have a valuation that is outside the bracket or found to be outside the bracket, that of itself is sufficient to demonstrate negligence. The Court of Appeal, following earlier authority, said that it wasn't. But there's an interesting point that comes out of this case that relates to the Manchester Building Society point, because even though the Court of Appeal held that it was bound by a decision, one of its earlier decisions, that said that if you have negligence in a valuation, but the valuation falls within the bracket, then there's no liability. Now, the Court of Appeal cast some, called into question whether that was right, notwithstanding the fact that it was bound by its earlier decision, and effectively set out why the Supreme Court may want to consider that point further in the future. It ties back to the Manchester Building Society case because the court didn't think that Manchester Building Society had altered what Lord Hoffman had said about that in the earlier Samco decision. So if you do have an adventurous client that wants to try and challenge that argument, that might be a case to have a read through. And then finally, there's the AXA France and Santander Cards UK Limited decision. Now, this is a recent decision in which the Commercial Court handed down a fairly substantial judgment of about £675 million. Some companies in this case that have been acquired by AXA underwrote PPI policies sold between 1970 and 2005 by GE Capital Bank Limited, which in turn was acquired by Santander in 2005. Now, the sale of those policies, as everyone's probably aware, created fairly significant liabilities as a result of PPI mis-selling complaints, which the AXA companies were responsible for under the relevant regulatory scheme. The court held that GE Capital Bank was liable to pay the AXA companies under an indemnity contained in an agency agreement. But the claim is also put in the alternative as a fallback in negligence, albeit that most of the negligence claim was at time barred. But nonetheless, in respect of the claim under this head, it was put on the basis that an agent owes its principal a common law duty to exercise reasonable skill and care, and that included an obligation to comply with the relevant codes of conduct that were in place at the time. The scope of duty point, I think, is quite an interesting one in this case because it says that in any event, though, the losses here weren't within scope because it wasn't foreseeable prior to 2010 that a statutory scheme or regime might subsequently be put in place, which would require redress to be paid for historic sales by reference to modern standards of acceptable selling and what's fair and reasonable, and indeed in certain cases without regard to rules of evidence on whether or not there was in fact any liability. Certain classes of compensation had to be paid out notwithstanding that a more detailed inquiry might have disclosed, for example, that the customer had all the relevant information and wanted the PPI policy anyway. And the argument was put forward that therefore these losses were effectively unforeseeable outside of scope and not the risk that any advice or conduct, I suppose, could reasonably have been expected to protect against at the time. Now, that was rejected by Mrs. Filthus Dias, who held that, as Manchester Building Society makes clear, the scope of duty is to be determined primarily by reference to the purpose of the duty, and in this case, the obvious purpose of the duty to comply with the codes of conduct was to avoid the principal being placed in breach by virtue of their agents' conduct. So that was sufficient in the judge's view to bring the regulatory consequences generically within the scope of duty. And she also rejected the argument that the mere fact that the regulator required redress to be paid when it might not be recoverable in a civil claim took it outside that scope.
I think I'm going to let Nathan draw breath and probably have some water and deal with just some general observations because we're nearly out of time. Thank you, by the way, for the questions that we've had. We've had just a couple, I think. So what do we conclude? My feeling, and I think this is illustrated by the really interesting trawl of cases that Nathan has just taken us through, is that it is probably the case that the Supreme Court in Manchester Building Society has enabled the court subsequently to have a degree of clarity in relation to the approach. So the 6 questions that were formulated by the majority, I think, have helped in relation to that. Importantly, of course, what you see from this is that the 6-stage framework and the purpose test remains very central to determining the question of the scope of duty. I think everybody thought when we first looked at Manchester Building Society that it would mean that, for example, concepts like SAMCO would be subordinate or would disappear. It clearly hasn't disappeared. It is still very much part of the test. So both in relation to the information advice distinction and also the use of counterfactuals. But I think we can say that those are subordinated to the central question now on purpose. Even in cases where scope is well established, then there might still be things to cross-check in relation to it. But I think key to this, and again, this is illustrated by a lot of the cases that Nathan's told us about, is it is important to identify the risk the professional was objectively meant to guard against at a very early stage, because as Nathan has said, insurers for defendants in these cases are still quite astute at challenging the scope of the duty. And in particular, as you saw from a number of the cases, even trying to do so at summary judgment stage or reverse summary judgment. I think, Nathan, unless you want to add anything, that probably brings us, we're 3 minutes short of our target.
No, I think that's, that does bring us nicely to a conclusion within time.
We've got one final question. Let me just... what the question says is, what's the lay representative scope of duty? We're acting for a client whose lay representative withdrew his claim without his knowledge and requested the tribunal to dismiss it. The employment tribunal did dismiss it. Requested consideration set aside the dismissal judgment. Consequently, the claim is not dismissed but remains withdrawn. I'm not sure I entirely, I'm not sure entirely, Bram, I follow exactly. It looks like it's a very specific factual inquiry. The answer is it will be determined by the same questions. In other words, you're still going to have to look at what the underlying purpose of the advice that's been given and the role that they've adopted. I'm going to slightly duck that unless Nathan wants to take it on. But it seems to me that the answer is the principles that we've described in MBS will apply in order to determine, but first of all and foremost, ask what falls within the scope of the duty.
Yeah, I mean, the only thing I'd possibly add to that is you're going to have to look quite carefully at what factually happened in the case to see what responsibility the lay representative took on in that case.
Yeah, I agree. I mean, I think there would be, my feeling is that there'd be a certain reticence about imposing extensive duties in those circumstances, particularly if they've been acting in effect gratuitously. I think that's everything else. Well, thank you very much. Can I just remind you that, as I said at the beginning, this is one of a series of 5 talks, and I'm sure that my colleagues would love you to join us. But most importantly, I want to thank Nathan and the staff at King's Chambers for putting the seminar on. But Nathan, as you can probably tell, has done most of the work in relation to this. But thank you very much for joining us, and we hope you'll be able to join us at the future seminars.